In a recent order, the Calcutta High Court voiced its concern over extreme pressure the lately enacted Bharatiya Nagrik Suraksha Sanhita or the BNSS might put on existing forensic laboratories, given that the new Criminal Procedure Code makes forensic examination mandatory in criminal cases where the punishment is more than 7 years. The Bharatiya Nagrik Suraksha Sanhita replaces the British-era Criminal Procedure Code and came into effect on 1st of July. While dealing with a 13-year-old suo motu cognizance case on inadequate number of forensic laboratories in the state, the Calcutta High Court said that to make forensic testing mandatory for certain offences would put burden on existing central as well as state laboratories to analyse forensic samples such as blood and other body fluids for DNA analysis collected from the crime scene. In this video, I will be explaining what this new provision is all about and why it has left the High Court concerned. As I told you, BNSS replaces the erstwhile Criminal Procedure Code and has been brought into use technology and forensic sciences in a bid to reform the criminal justice system. However, controversy has already shrouded the code as well as the other two penal laws, that is, the Bharatiya Nyaya Sanhita, which in its earlier avatar was called the Indian Penal Code, and Bharatiya Sakshya Adhinayam, which was the Evidence Act. Experts have criticized the government for drafting the three legislations without adequate consultation and notifying them in a hasty manner. Now, in particular, Section 176 of the BNSS, which provides the framework for criminal investigations, has added a provision mandating forensic evidence for certain offences. And this section has to be operationalized in the next 5 years by the respective state governments. I would digress a bit to explain why the state has been asked to operationalize this section. Under the Constitution, states are authorized to implement law and order. Hence, even though the centre has promulgated the three new criminal laws, their implementation on the ground is the task of each state government in the country as per the Constitution. Now, to get back to the BNSS. So, Section 176 of BNSS provides for a broad procedure that investigating agencies should follow after a crime is committed, including how a police officer receives information on a crime and acts on it. Subsection 3 of this section mandates that forensic experts collect forensic evidence from the crime scene for every offence that carries a punishment of more than 7 years. As per the procedure outlined in the law, forensic experts would have to visit the crime scene after the police are informed about the incident. These experts under the new law are required to collect forensic samples from the spot, which will then be used by the police for their investigation. Let me quote the section to tell you what it exactly says. It reads as, on receipt of information relating to the commission of an offence, which is made punishable for 7 years or more, the officer in charge of a police station shall cause the forensic expert to visit the crime scene to collect forensic evidence in the offence and also for videography of the process on a mobile phone or any other electronic device. However, as stated above, this provision will only be applicable and operational once the relevant state government decides a date for its implementation. Once the state government decides the date, it has to notify this in the Gazette, after which the section will take effect. The law outlines a timeline of 5 years for states to carry out this task, but it is silent on the consequences for state governments that do not fix a date for the application of this section. However, once the states do their part, for any offence that carries a jail term of more than 7 years, it will become compulsory for the police to get a forensic examination conducted on the crime scene, which has to be executed on the orders of the in charge of the police station. Therefore, offences such as rape, child trafficking, murder and dowry death, all of which carry terms of more than 7 years, fall within the purview of the additional requirement to collect forensic evidence from the crime scene. If a state does not have a forensic facility to conduct such tests, the law allows a forensic testing facility in another state to do it. How is the new procedure code different from the outdated one in this context? Well, the erstwhile Criminal Procedure Code had no defined legal requirements for forensic evidence collection from crime scenes. Whether or not such evidence was required was left to the discretion of the state police. Even though its intentions are to make police investigation more efficient in heinous crimes, the law has raised several concerns, including the broad scope of forensic data collection extending to private persons, the expanded scope of personal data collection, and exemptions restricting judicial interference with forensic reports. To meet the infrastructure requirements brought in by the new law, the Centre has already set up the National Forensic Science University to expand the pool of forensic science experts and scientists qualifying every year. Laboratories such as the Central Forensic Sciences Laboratories in Delhi are also undertaking steps with training and special workshops to prepare their personnel, considering the massive resources and infrastructure required for effectively implementing the new law at scale. But the Calcutta High Court order highlights a pivotal point with regard to lack of infrastructure in states that are required to ensure compliance of this law. Observing the new law would put immense stress on state laboratories. The High Court has directed the Union government to designate Kolkata's National Institute of Biomedical Genetics, or the NIBMG, a laboratory which is wholly owned by the centre, as a central forensics laboratory. This would designate scientists working there as government scientific experts, enabling them to be witnesses before courts under the law.